Good afternoon and welcome back to the second plenary session on Doctrinal Study Group towards a harmonized subject matter curriculum which respects the diversity of approaches. I extend a heartfelt welcome to all the dignitaries present here. Taking this session further, I would like to extend a warm welcome to the chair of today's session, Dr. Luis Gabriel Franceschi, Dean Strathmore University, Strathmore Law School, Kenya, and IALS Law Board member. I would also like to welcome our panelists, Sital Kalantri, Professor, Cornell University, Cornell Law School, United States, Chair of Human Rights Law, Bettina Cahill-Wolf, Dean, University of Lausanne, Switzerland, Co-Chair of Constitutional Law, Anthony Kakuza, Dean, Uganda Christian University, Faculty of Law, Chair for Property Law, Emmanuel Magate, Dean, University of Zimbabwe, Faculty of Law, Zimbabwe, Chair for Contract Law. Dr. Luis Franceschi, LLB, LLM, and LLD, is the Dean for Strathmore Law School. Sir is a law lecturer and legal advisor to several national and international government agencies, commissions, and programs, including the United Nations and the World Bank. Sir is also a weekly columnist with the Daily Nation newspaper. He has taught leadership executive courses in more than 25 countries. Sir has various publications to his credit, some of them The Rule of Law, The Cost of Constitution in Kenya, and The Constitution of Kenya being some of them. Sir also sits on several boards like the Transparency International, the International Justice Commission, International Association of Law Schools, and Socian Energy, among others. Sir, we are indeed privileged to have you amongst us. Now, may I request Sir to take over the mic and conduct the session.
Thank you very much. Now, we will do this in a very interesting fashion. We are beginning late, and as it happens in India, when you are driving, you need three things. Good luck, well, first they say a good horn, good brakes, and good luck. So we will have in this session good horn, because I will be warning them when the time is over, good brakes to stop talking when we have to stop, and good luck hoping that we catch up a little bit of time and we don't end so late. Then we'll follow this order of the program. We'll begin with Sital, who comes from Cornell University, Cornell Law School. We'll proceed to Switzerland, from the US traveling to Switzerland, and then we'll go back to Uganda, flying over Kenya, back down to Zimbabwe with Emmanuel Magade. And I have been asked at the end to close the session with a short presentation of an experiment that is putting this innovation and curriculum together, and we hope we will be all in time. So, Professor Sital, the floor is yours. Yes, you can have the podium. A big clap.
Thank you for that prompt. So thank you, Dean Franceschi, the Symbiosis Law School, for hosting, Dean Wang and Dean Barbara Holden-Smith, my co-panelists. It's a pleasure to be here to talk with you today. So the doctrinal study groups, it seems to me, have an impossible task. How do we harmonize a law curriculum, but still take into account the differing contexts and approaches? At first blush, this may seem a contradiction. We are being asked both to harmonize a curriculum, but at the same time not harmonize it. So let me offer some thoughts about how we might proceed. The word harmonization brings to mind the European Union, of which I know very little. But as part of the supranational organizations, countries were being asked to harmonize their laws and regulations to some extent. While there's no agreed definition, even in that context, some believe that harmonization should mean the creation of certain minimum standards. So when countries in the EU adopt these minimum standards, it facilitates commerce and interactions among people across national borders. Maybe it's fruitful for us to think about harmonization in this way, as the process of creating minimum standards within each doctrinal group. In other words, each group can identify broad topics and skills that are a baseline core for any curriculum, the minimum requirements. Then the next question is, well, how do we take the context into account? This may be harder to do in some doctrinal groups than others. In the group that I have the privilege of chairing, the human rights group, we have it a little bit easier. We have a common set of documents in the world, the UN treaties, and a common group of bodies, UN institutions, that interpret and adjudicate obligations of state parties under these treaties. But clearly, there's also domestic context that forms what we think of as human rights. Domestic constitutions, statutes, as well as regional human rights bodies are relevant and important. So one way to both harmonize and contextualize is to create several alternatives that can be adopted in addition to the minimum standards, different alternatives for different contexts. For example, the curriculum could provide alternative areas or subjects based on whether the jurisdiction is a common law or civil law. There may be other options in the menu of alternatives. Moreover, even the exact substance of the topics that form the minimum standards could vary based on what is contextually appropriate. So having given very general thoughts, and this is my first year here and new to this, so I apologize if this is very basic, but having framed one way that I've been thinking about how to harmonize and contextualize, I wanted to illustrate the benefits of doing so with reference to a class that I taught last semester. So I taught a class with 2 law professors at the National Law University in Delhi, Aparna Chandra and Mrinal Satish. Our joint class had 8 students physically located in Ithaca, New York, and 8 students physically located in New Delhi. We met every week by video conference. The class was focused on learning the substantive law, moral theories, and policy as it relates to surrogacy, which is surrogacy is where a woman will bear a child for other people, and how it relates to human rights. Every student in this joint class read the same articles every week. I taught the US law portions of the class, and my Indian colleagues taught the Indian law portion. Immediately, this became a comparative law class. Students in India had to learn that in the US, surrogacy law, which consists of family law and contract law, is state law and changes on the basis of what state you're in. American students learned the unitary Indian system of federal courts. This was also a clinical class, and as such, there was a practical application of the academic knowledge they garnered, as well as fact development component. The students from the United States traveled to India, and together with the Indian law students, they interviewed doctors, surrogates, lawyers, and agents involved in surrogacy. Our goal was to bring their voices to the Indian Parliament, which was considering at the time and continues to be considering a surrogacy bill to ban surrogacy in India. We submitted a report. The students drafted this report together, and we agreed on it by majority vote as to what our position would be. We submitted it to the Standing Committee of the Parliament that was considering the bill. The committee included large portions of our students' memo and work in their own report, which I might add without attribution, but we're okay with that. In the class, students learned how to collaborate across cultures and time zones, moved from theory to empirical data, and proposed practical solutions to complicated problems. And we had the good fortune of having measurable results. So I have 2 minutes left. I'm going to very quickly. So just before I conclude, I'll just very quickly show you some pictures. This is the students when we traveled to New Delhi in the conference room at NLU, which some of you may recognize. And then these are interviews that we did with fertility specialists and doctors, interviews in the National Commission for Women, as well as the American Embassy. And finally, the instructors were very conscious that we didn't want the legal advice and policy flow to flow one way from the global north to the global south. So another part of our work was to also submit a legislative policy report to the New York State Legislature, which ironically was simultaneously as India was considering banning surrogacy, our legislature was considering legalizing it. And so this is the cover of the report. Interesting, some Indian students were uncomfortable with it from a women's rights perspective in India, but were perfectly fine in the US. The Indian law students clearly understood that there's a huge gap between law on the books and law in reality, which many of the American students were not initially conscious of. So this, coming back to the original point, this intense teacher and student collaboration was possible only because we all shared a minimum set of standards. We communicated in a common language, though understanding that American English and Indian English are not necessarily the same. The professors agreed upon and drew upon the same sources of knowledge, and we utilized similar lawyering skills in both countries in which we conducted fact-finding. Yet the students learned the importance of contextualization. They proposed slightly different policy solutions for India and for New York, based upon their understanding of the strength of common law, the enforcement of law, and the differing social contexts of inequalities in each of the two countries. Thus, it is possible to harmonize and contextualize if we think of harmonization as minimum set of standards and contextualization as alternative proposals for different jurisdictions. Indeed, I believe that this joint clinic I taught was successful only because we were able to do both of these things at the same time. Thank you.
Thank you, Sital, for that fantastic experience. It's enriching us, enriching the curriculum, and we now give the floor to Bettina from Switzerland, and tell us your experience, Bettina.
Yeah, thank you very much. I hope it's fine with you if I'm sitting. I listened very carefully today to this very nice introduction to yoga exercise, but still I have some pain in my hip, so I'm very glad if I can just sit. So thank you to our chair for introducing me, and I also would like to thank you, IALS, and also, of course, Symbiosis Law School for inviting me. So, as you know, so I come from Switzerland. Switzerland is quite a small country, much smaller than India. It's not even a member state of the European Union, although it's in the middle of Europe. And so it's not a member state, but it's greatly influenced by the law of the European Union, and so is the legal education in Switzerland. I would like to say that in Europe, harmonization and diversity are two keywords that go together. First, we have the Bologna model. This gives us the structure of the curricula, and they were harmonized, and Switzerland did adopt also the Bologna model. I know that other countries in Europe did this also. And this model is structures through two steps. We have a first degree, a bachelor degree after 3 years, and then a master degree after 2 years. But besides the structure, there is also a tendency of harmonization in the contents of the law teaching. I would say that all over Europe, besides some specialties, you can see two pillars. We have national law on the one hand and the international law on the other hand, and both laws, both parts of the legal system are influenced by the law of the European Union. So you may take fundamental rights, you may take administrative law principles, even torts and contracts or criminal procedure. You can observe common streams in the legal system of European countries. And as a consequence, the curricula are also quite similar. And I would like to state that all over Europe, students learn the value of fundamental rights, learn how to check whether public measures are respectful of public law principles, and of course they have to develop skills that allow them to defend a person towards another public or private person. So I would summarize and say legal education is harmonized in Europe, and small Switzerland is kind of part of it. But the other key word is diversity, and Cital already said this is a kind of opposite, to have harmonization and how to deal then with diversity. So of course you have diversity, especially in Europe with so many different countries. It starts already on the level of the language. For instance, in Switzerland we are teaching law. I start with the bigger community. We teach in German, in French, and also now in Italian. So that is quite different also when you approach the law in different languages. And then also, of course, every country has another legal system and another special internal law. So there are some fields that are not harmonized, like we already talked about this family law, for instance, or also my field, which is social security law. So we heard about diversity this morning also by Dean Jakobstelina from Poland, who told us certain specific problems of his country. But all in all, I would like to say that the curricula in Europe are largely harmonized under the influence of European law, but some fields, they are shrinking, are diverse. So this picture is not that much a result, I think, of a decision that law schools say, okay, we need to harmonize, or let's harmonize. I think it's more, it comes by itself somehow, because the law in Europe is getting harmonized, and so is then the legal education. On the other hand, legal